Good morning, everyone. Welcome to the morning session of webinar organized by Government Arts College, Trivandrum. In this session, I am going to handle important topics related to cyber law, its objectives, importance, the different categories of cyber law, a description about the IT Act in India, and I'm mainly dealing with the Indian laws relating to intellectual property rights. So let us begin the session with what is the meaning of cyber law. Cyber law is an area of law that deals with internet, cyberspace, and their respective legal issues. It is also called as the information technology law or the internet law. It is related to the legal informatics and supervises the digital circulation of information, software, information security, and e-commerce. So, cyber law is the law governing the cyberspace. Now, what is the cyberspace? Cyberspace is the environment of the internet world. The term cyberspace was coined by William Gibson in the year 1982. It includes computers, networks, software, data storage devices, internet, websites, email, and also include electronic, medical, and biometric devices. So shortly we can see that computer generated world of internet is called cyberspace, and the laws prevailing in this area is known as the cyber law. The importance and scope of cyber law is ever increasing as we are becoming more and more dependent on internet and related technologies for our day-to-day functioning as individuals and as a society. Cyber law yields legal recognition to electronic documents and a structure to support e-filing and e-commerce transactions, and also provides a legal structure to reduce and check cybercrimes. So, like any other law, a cyber law is created to help and protect people and organizations on internet from malicious people and help to maintain secrecy and privacy of information. The main aim of cyber law are as follows. First one, to create more awareness about cyber legal issues and challenges, to provide advice, inputs, and also guidance to people on day-to-day legal issues concerning the use of cyberspace, to work on research and development on issues and challenges in cyberspace, to contribute to the global debate on evolving cyber law jurisprudence, to coordinate with other concerned stakeholders in the digital environment so as to contribute to the evolving cyber laws, and finally to provide legal assistance and advice to people who have been affected by the misuse of cyberspace and connected services. Now let us move on to the importance of cyber law. First of all, it ensures integrity and security of information. Secondly, it maintains privacy and confidentiality of information. Thirdly, it helps to tackle cyber crimes. Fourth, it protects the intellectual property rights. Fifth, it provides economic efficiency. And lastly, it helps in smooth functioning of e-commerce transactions. Now we'll see what is the present scenario of cyber law in different countries. We know that there are 7 billion people in this world and approximately 50% are internet users, and the number just keeps on increasing exponentially. The 21st century can be very easily called as an internet century because the internet has got such an immense power. We all know that it has immense power to break someone, it has a power to impact the world's policies and decisions, and in fact, an internet can also change the world. So with this power, it creates or brings so much responsibilities also. With increasing popularity of online activities, the rate of online crimes has also increased seriously. So various cyber crimes have evolved and are evolving constantly. So different countries have developed laws to deal with these issues. In India, we also have a cyber law, and in India, the cyber laws are contained in the Information Technology Act of 2000. The main purpose of this act is to provide legal recognition to e commerce and facilitate filing of electronic records with the government. The first cyber law in India was the IT Act of 2000, which was enacted on 9th June 2000 and came into force on October 17, 2000. It is the first cyber law in India, IT Act 2000. This IT Act 2000 was amended in the year 2008, which came into force on 27th October 2009. And now, this IT Act 2008 contains 14 chapters and 124 sections. The cyber laws, that is the IT Act of 2000, is divided into four sections. Laws relating to digital contracts, laws relating to digital properties, laws relating to digital rights, and laws of cybercrimes. So now let us examine the Indian laws relating to digital properties. Now first of all you have to understand what is a digital property. Digital property means an electronic record in which a person has a right or interest. It can be also called as a digital asset. An intellectual property is also a digital asset which forms a very important part of IT law. Now let us check the meaning of intellectual property. Intellectual property is a combination of two words, intellect and property. Now, what do you mean by intellect? Intellect means using your mind. You're creating something. You're using your brain or mind to create something. And property, in the sense, it means an asset which gives you a bundle of rights. Okay? So, intellectual property is an intangible property which is created by using a human intellect and that has got a commercial industrial value. And intellectual property rights are those legal rights which is exclusively given to the owner of the creator of that particular intellectual property. Now, this intellectual property can be an invention, a piece of music, an artistic work, a name, a slogan, a symbol, or a design. So, all these categories can be considered as intellectual property. According to WIPO, there are 7 categories of intellectual properties. The following are the different categories. Patents. Patents are inventions granted under the Patent Act of 1970 to protect or to give exclusive right to the patent holder regarding his inventions. Second one is trademarks. Trademarks are graphical representations which are capable of distinguishing your product from another product. It can be a sign, symbol, logo, label, name, signature, letters, or even a numeral. Next is the layout design of integrated circuits. The Article 35 of TRIPS agreement requires the member countries to protect their layout designs of integrated circuits. Copyrights. That is another intellectual property. Copyrights are those laws that covers published and unpublished literary, scientific and artistic work. It gives the creator, whoever is a copywriter, the exclusive right to protect his work from being copied. Next is trademarks. Trade secrets. So according to section 39, the protection is given to trade secrets. Trade secrets are confidential business informations which are the most valuable assets of business enterprises. They are completely owned and the monopoly is purely enjoyed by that business who is having that confidential information. Another one is plant breeders' right. So, plant breeders' right refers to the protection conferred on plant varieties that are new, stable, homogeneous, and identifiable. And these rights are given on the basis for the development of new varieties of plants by the use of a protected variety of another plant. Then, industrial designs. Industrial designs includes uh, any design or model which needs to be protected and which is applied in a particular industry. And geographical indications are now also they are also now considered as an intellectual property whereby you can protect any particular type of food product or any plant variety or what or you can anything which can gives fame to the state can be also considered as a geographical indication property or a intellectual property. Now I'm moving into the next topic, which is the IPR laws in India. So here I am going to discuss certain important laws relating to patents, copyrights, and trademarks. First one is patent law. The patent law in India is governed by the Patent Act of 1970. The Patent Act was amended by the Patent Amendment Act of 2005. Patent law is that area of law that deals with an inventor's exclusive right to use their own invention. It empowers a patentee or the patent owner to prevent or stop the use of his or her invention by the third party. It also includes the license to use, sell, or even mortgage the patented invention. So, in order to get your invention to be patentable, what are the three conditions? First of all, the subject matter should be new. Secondly, it should be useful to the society. And thirdly, it must be of vendability. That means that it must be capable of being marketed for commercial purposes. So, if it satisfies these three conditions, first of all, it should be new. No one has invented this thing before. So it should have novelty, and it should be useful to the society. It should not do any harm to the society. And third is that the subject matter or the content of the patent should be commercially used. It should have a utility. And you can see different types of patents. You have utility patents, design patents, plant patents, etc. And utility patents are those patents which includes machines, process, method, compositions which can be used for a specific group. And design patents are those involving a new design, shape, or a general ornamentation. And plant patents for the discovery or inventions of new variety of plants, etc. So these are the areas where you can see patents. Okay, and 90% of the patents are utility patents. Now we can see different sections under patent law. First one is section 21J, which defines what is an invention. Section 21M defines what is a patent, and section 34 mentions the items which are not patentable. Section 34 describes the items which are not patentable. First one, discoveries are not patentable. Discoveries are not patentable. For example, Isaac Newton discovered gravity, but he cannot claim that law of gravity as a patentable product because law of gravity was already there in the universe. Second is that agricultural methods are not patentable. Suppose you are inventing any method to produce new method of agricultural productions, then that is not a patentable one. Then any process of medicinal surgical treatment is also not patentable. Now we can see what is the general term of a patent. The general term of a product patent is for 20 years according to section 53. So these are the important sections coming under the patent law. Now let us see the requirement for the grant of a patent. First of all, the application should be made at the Indian Patent Office. Second is that any person, Indian, foreigner, individual, company or government can file the patent application. Thirdly, the person applying for patent shall be the true or the first inventor of the invention proposed to be patent. So these are the conditions for considering your patent by the Indian Patent Office. Now, in case of an infringement of the patentee, infringement of your patent, the patentee can file a suit in the court according to section 106. So according to section 106, your patent, if it is infringed by any other person, then you can file a case in the court and you will be provided damages according to section 106 of the Indian Patent Law. Now we are going to find out the Trademark Act of 1999. In India, the trademarks are governed by the Trademark Act of 1999. Trademark means any sign, symbols, design, expression, tagline, logo, abbreviations which recognize or identify a product. It distinguishes it from other product. The Indian trademark is protected under the Trademark Act of 1999. Now let us see the objectives of this Trademark Act. First of all, it provides registration of trademarks. It provides better protections of trademarks and also prevent the use of fraudulent trademarks on merchandise. There are different types of trademarks. Product trademarks, which is attached to goods to distinguish it from others. Example, Bata, Amul. It includes service trademarks, which distinguishes the services of one owner from another, like Yahoo, Google. It also includes collective trademarks, which are used to inform collectively about the product to the public, like Tata, Reliance, they use collective trademarks. Then, certification marks can be also called as what? Trademarks. It ensures quality and standard of the product. Example, ISI mark. It is given to for the standardizations of products. Eco mark. You might have heard about eco mark. Eco mark is given for ensuring the eco-friendly. That is, it is an eco-friendly product. And rug mark. Rug mark. You might have heard about rug mark. It is given to those products where child labor is not being used. It protects child labor. Okay. Then in addition to this, you have shape marks. Shape of the products, packaging also can be protected under the trademark law. Example, you know that Kit Kat chocolate, they have a unique shape other than other chocolate. Cadbury's, Kit Kat, they have a unique shape, right? Design. So car models all comes under shape marks. Then sound marks. The MGM roar of a lion, it's an example for sound mark. Then slogans or taglines. Different institutions have their own slogans and taglines. So they're all coming under trademarks. Now, what are the procedures for these trademarks? First of all, you have to give an application for registration of trademark under Section 18 of the Act. And secondly, the application is advertised under Section 20 of the Trademark Act of 1999. And under Section 22 of the Trademark Act, the applicant can make any amendments or changes in his application. And the registrar is entitled to register the trademark within 18 months under Section 23. And what is the validity of this trademark that you have created? The trademark registered is valid for a period of 10 years, and if you want, you can renew it for a term of another 10 years. Now, regarding the infringement of trademark, if an unauthorized person uses a trademark that is identical or very similar to your registered trademark, then it will be called as infringement of your trademark. So, what are the remedies for it, or what you can do? When a trademark is said to be infringed, both criminal and civil actions can be brought about, and the court will give an injunction of stay against the use of the trademark and give appropriate damages to the original user. So, that is all about the Trademark Act of 1999. Now you'll see what is a copyright law. Copyright is an intellectual property which gives the owner of the work an exclusive right to protect his work. So let us see what are the works which are covered under the copyright. It includes artistic work, literary work, musical work, dramatic work, cinematography, sound recording, architectural work, or it can be a graphical and sculptural works. So, if any of the person has worked in this category, it can be protected under the copyright law. In India, we have the copyrights law, and the copyrights are governed by the Copyright Act of 1957. And this act has been amended almost 6 times, and now the latest amendment was in 2012, and now we have the Copyright Act of 2012. So the term of a copyright is that it lasts for 60 years. So if you have a copyright on some of your work, that will last for 60 years. Now let us see the important sections of this Copyright Act. Section 9 of the Copyright Act 1957 requires for the establishment of an office which is called as a copyright office. So if you want to get a copyright of something, then you have to approach this copyright office. And now the headquarters of copyright office is situated in New Delhi. And in this copyright office, there will be a copyright registrar. So it is this registrar who is handling the registration of these copyrights. Section 44 and 45 provides for the registration of copyrights. And sometimes your copyrights might be infringed. So section 51 of the Copyright Act 1957 speaks about the infringement of your copyrights. When your copyright has been infringed without a license, then the owner of the copyright or the registrar himself shall be entitled to civil remedies by way of injunction damages. And punishment can be also given for infringement, and it is mentioned in section 63A, 63B, 65, 68 and 70 of the Copyright Act 1957. So that is all about the laws relating to various intellectual property rights in India. I have dealt with the major laws. Now let us see the ways to protect the digital intellectual properties. The digital rights management, also known as electronic rights management system, ensures the protection of intellectual property rights. Another way to protect the digital content is through technical protection measures, that is TPM. In both this TPM and DRM technologies, we can protect the content, whatever content that you are using in intellectual properties. So let us see the various methods which are used to protect the intellectual properties. It includes cryptography, digital watermark technology, you can use digital signature technology, and also electronic marking. So these are the various ways where you can protect your intellectual property rights. Thus, we can conclude that the management of intellectual property and intellectual property rights is a multi-dimensional task and requires different actions and strategies. Intellectual property contributes enormously to our national and state economies. So, strong and enforced intellectual property rights protects consumers and families. For this, the legal infrastructure like cyber laws need to be strengthened. Thank you very much.